The bailiff's grip tightened around her wrist before Dr. Simone Carter could finish her sentence. 1 heartbeat. That's all the time she had before her body collided with the cold marble wall of Courtroom 7A. The sound echoed through the chamber like a gunshot, sharp, final, impossible to ignore. Her leather briefcase tumbled from her hand, its brass nameplate clattering across the polished floor, spinning once before settling face up. The engraved letters caught the overhead fluorescent light. Chief Medical Director, Bureau of Correctional Health Services. Simone stood in traffic court, Jefferson County, Indianapolis. She was here for something absurd. A speeding ticket, 39 miles per hour in a 35 zone, 4 miles over the limit on Meridian Street during morning rush hour. She'd been on her way to a conference call with the State Attorney General's office, a routine check-in about prison healthcare standards. Nothing urgent. Nothing worth this. Officer Marcus Brennan had been watching her from the witness stand. He sat there with his arms crossed, his patrol uniform crisp and dark blue, his badge gleaming under the lights like it had been polished that morning. When Simone entered the courtroom, he leaned toward Bailiff Eugene Watts and whispered something. Watts was 54 years old, a 26-year veteran of courthouse security. His personnel file, buried deep in administrative records, contained 17 formal complaints. None had resulted in disciplinary action. Not one. Watts approached Simone with heavy, deliberate steps. His boots struck the floor in a rhythm that felt practiced, rehearsed. "Ma'am," he said, his voice loud enough to carry across the room. "You can't stand there. Defendants wait outside until called." Simone kept her voice calm, professional. "I am a defendant. My hearing is scheduled for 2:15. Case number TR 202493382. Watts raised his voice. "Don't get smart with me. Move. Now." Before we go deeper into this case, take a second and hit that subscribe button. Give this video a like, and let us know where you're watching from. I'm curious to know how far these stories travel. Have you ever been invisible? Not literally, of course, but invisible in the way that matters when your words don't register, when your credentials don't count, when your very presence in a space is treated like an intrusion. Simone reached into her jacket pocket to check the printed docket confirmation. That's when Watts grabbed her wrist. The force wasn't tentative. It wasn't a tap or a warning touch. He grabbed her with the full strength of a man who'd done this before, who'd learned over decades that he could, and yanked her sideways. Her left shoulder hit the marble wall first. The pain was instant and electric, shooting down her arm like lightning branching through a storm cloud. The impact knocked the air from her lungs. Her silk blouse tore at the shoulder seam. A small sound escaped her throat, not a scream, just a sharp exhale of shock and pain. Judge Eleanor Whitmore looked up from the bench. She was 61, white, with silver hair pulled into a tight bun, and reading glasses perched on the bridge of her nose. She'd been a judge for 19 years. She glanced at the disturbance, with the kind of mild irritation you'd give a ringing cell phone in a library. "Bailiff," she said, her tone flat. "What's going on?" Watts didn't release Simone's arm. His fingers dug into her wrist hard enough to leave red marks that would darken to bruises by evening. "Uncooperative defendant, Your Honor. Resisting lawful instruction." Simone kept her breathing steady, despite the pain radiating from her shoulder down through her ribs. "Your Honor, I was assaulted. I am Dr. Simone Carter. I'm here for traffic case TR 202493382. I was standing calmly when the bailiff grabbed me and threw me against the wall without provocation." Judge Whitmore barely looked at her. She turned a page in the case file on her desk. "Doctor or not, you follow bailiff instructions in my courtroom? Sit down, or I'll hold you in contempt." Officer Brennan smirked from the witness box. He leaned back in his chair, arms still crossed, watching the scene unfold like it was a rerun of a show he'd seen a dozen times before. His uniform was immaculate. His badge caught the light. His expression said everything. This is routine. This is normal. This is how things work here. Simone bent slowly, to retrieve her briefcase. The dented brass nameplate had a fresh scratch running through the letters of her title. She opened the case, and for just a moment, the contents were visible. A laminated Bureau of Correctional Health ID with her photo and title in bold capital letters. A leather portfolio embossed with National Healthcare Leadership Summit. A first-class boarding pass to Washington, D.C. for the following morning. A folder marked Confidential with the state seal stamped in blue ink across the cover. She walked to the back row of the gallery and sat down. Each step sent a fresh wave of pain through her shoulder. She didn't cry. She didn't shout. She sat with her back straight, her hands folded on top of the briefcase, and waited. A young black man in the third row had watched the entire thing. His name was Terrence. He was 24, a second-year law student at Indiana University's McKinney School of Law. He'd come to observe traffic court proceedings for a clinical assignment on judicial discretion. What he witnessed instead was something his constitutional law professor had warned him about, but that he'd never seen so blatantly displayed. He pulled out his phone and began recording discreetly, keeping it low and steady. His hands shook, but the video stayed clear. He'd learned in his evidence class that documentation was the difference between a story and proof. Simone pulled out her phone and typed a message. Delayed. Incident at Courthouse. Proceeding as planned. She sent it to a contact saved simply as Governor's Office. The reply came within 15 seconds. Call me immediately after. This cannot stand. Judge Whitmore moved through her docket with mechanical efficiency. She had 37 cases scheduled before 3:30 that afternoon. Most were traffic violations, speeding tickets, broken taillights, expired registration tags. She spent an average of 3.5 minutes per case. When Simone's case was called, she stood and walked to the defendant's table. Her shoulders screamed with every movement, but her face remained neutral, composed. Officer Brennan took the stand. He placed his hand on a Bible worn smooth from use and swore to tell the truth. Then he sat down, adjusted the microphone, and began. Defendant was driving erratically on Meridian Street, 46 miles per hour in a 35 zone. When I initiated the traffic stop, she became verbally combative. She questioned my authority and my right to pull her over. She refused to provide her license and registration initially. She made threats about reporting me to my supervisor. Simone listened without expression. Her hands rested flat on the table. When Judge Whitmore asked if she had anything to say, she spoke clearly, her voice steady. Your Honor, my dashcam footage shows I was traveling 39 miles per hour, not 46. The video also shows I was polite and cooperative throughout the entire stop. I said, "Good afternoon, officer." I provided my license and registration within 10 seconds of being asked. I asked one question about whether the speed limit sign was visible from my lane. I made no threats. I filed no complaints until today. Judge Whitmore raised an eyebrow. You have dashcam footage? Yes, Your Honor. I can provide it immediately via email or USB drive. I'd also like to file a formal complaint against Bailiff Watts for assault. I was standing still when he grabbed me and threw me against the wall. There was no justification for that level of force. Watts stepped forward from his position near the courtroom door. His face flushed red. She lunged at me, Judge. It was self-defense. She was reaching for something in her bag. I had to act to protect the court. Officer Brennan nodded quickly. I saw it too, Your Honor. She was aggressive and belligerent outside the courtroom before we even came in. I had to warn her twice about her tone and her behavior. Judge Whitmore sighed and removed her glasses. She rubbed the bridge of her nose like this was all just another inconvenience in a long day. Dr. Carter, I'm inclined to believe my officers. They serve this court with distinction. They have no reason to fabricate testimony. Guilty on the speeding violation. $290 fine. As for your complaint, file it with Courthouse administration on the 4th floor. We're done here. Next case. Simone remained standing. Your Honor, I respectfully request that you review my dashcam footage before entering a final ruling. It directly contradicts Officer Brennan's sworn testimony on multiple material facts. The judge's face hardened. Her jaw clenched. Request denied. I've made my decision based on credible testimony from a sworn peace officer with 12 years of service. Sit down or leave my courtroom immediately. Simone nodded once. She returned to her seat. She made no sound. She didn't argue. She didn't plead. She sat down, opened her briefcase, and pulled out a yellow legal pad. She began writing in neat, precise handwriting. Timestamps, observations, names, badge numbers. Terrence, the law student, had captured everything on video. 7 minutes and 43 seconds of uninterrupted footage from the moment Watts grabbed Simone until she sat back down. Clear audio, clear video. He saved the file to 3 separate cloud accounts before leaving the courtroom. Outside, in the 4th-floor hallway, Simone found the Office of Courthouse Administration. A tired-looking clerk handed her a complaint form. Standard procedure, the clerk said without looking up from her computer. Fill it out. Drop it in the box. Someone will review it within 90 days. Simone filled out the form. She checked every box. She wrote a detailed narrative on the back. She attached a business card with her full credentials listed. Then, she didn't drop it in the box. She asked to speak with the courthouse administrator directly. The clerk looked up for the first time. Dr. Carter, the administrator doesn't meet with complainants. That's not how this works. I'm not leaving until I speak with someone in authority. I was assaulted by a courthouse employee in front of a sitting judge who witnessed the assault and did nothing. I will wait here as long as necessary. The clerk picked up her phone. 20 minutes later, Simone sat across from Howard Chen, deputy courthouse administrator. He was 48, Asian American, with wire-rimmed glasses and a tie that had been loosened at some point during the day. He'd been with Jefferson County courts for 16 years. He looked at Simone's complaint form and then at her credentials, and then back at the form. Dr. Carter, I'm going to be honest with you. Bailiff Watts has had complaints before, several of them, but they've never been sustained. Judges trust him. He's been here since before I started. Without video evidence or independent witnesses, these cases are very difficult to prove. Simone reached into her briefcase and pulled out her phone. I have video evidence, and I have a witness. She played the footage Terrence had sent her during the hearing. Watts grabbing her wrist, the slam against the wall. Judge Whitmore's dismissive response. Officer Brennan's smirk. Howard Chen watched the entire video without speaking. When it ended, he sat back in his chair and exhaled slowly. This is very concerning. I'm going to need to escalate this immediately. Can you send me that video? I've already sent copies to the governor's office, the state attorney general, and the ACLU. I'm sending you a copy now as a courtesy. But I'm not relying on internal review processes that have failed to hold Bailiff Watts accountable for 17 previous complaints. Chen's eyes widened. How do you know about his complaint history? I'm the chief medical director for the Bureau of Correctional Health Services. I have access to state personnel databases. I pulled his file this afternoon from my office. 17 formal complaints spanning 14 years. 0 sustained findings. 0 disciplinary actions. That's not coincidence. That's pattern. Before we continue, take a second and share your thoughts so far on this story below. I read every single one. Chen leaned forward. Dr. Carter, what do you want? I want Bailiff Watts removed from duty, pending a full investigation. I want Judge Whitmore's dismissal of my complaint, reviewed by the Judicial Conduct Board. I want Officer Brennan's testimony referred to the prosecutor's office for potential perjury charges. And I want systematic reform of how this courthouse handles complaints against security personnel. That's a lot. That's accountability. Chen promised to begin an investigation immediately. He promised to review Watts's personnel file personally. He promised to forward the video to the appropriate oversight bodies. Simone thanked him politely and left. She didn't believe a word he'd said. She'd worked in bureaucracies long enough to know the difference between promises and action. That evening, Simone sat in her home office in the Broad Ripple neighborhood of Indianapolis. Her shoulder throbbed despite the ice pack and ibuprofen. She opened her laptop and began a process she'd perfected over 18 years of medical research: systematic data collection. She started with Jefferson County Courthouse traffic court records. They were public. Anyone could access them online through the county clerk's website. She downloaded every traffic court case from Judge Whitmore's courtroom for the past 5 years. 4,327 cases. She exported them to a spreadsheet and began coding variables. Defendant name, defendant race, determined from newspaper photos when available, census data when not, citation type, guilty or not guilty verdict, fine amount, whether the defendant had legal representation, whether the defendant presented evidence, whether the judge reviewed that evidence. It took her 6 hours that first night. Her shoulder ached, her eyes burned from staring at the screen. But patterns emerged like constellations becoming visible as your eyes adjust to darkness. Judge Whitmore found black defendants guilty 91% of the time. She found white defendants guilty 63% of the time. For identical citations, same violation, same circumstances, black defendants paid an average of $47 more in fines. When black defendants presented video evidence contradicting officer testimony, Judge Whitmore reviewed that evidence in court only 12% of the time. When white defendants presented identical evidence, she reviewed it 68% of the time. The numbers were stark, undeniable, damning. Simone expanded her research. She pulled records from all 8 traffic judges in Jefferson County. She pulled records from neighboring Marion County for comparison. She spent 2 weeks building a database that would make any epidemiologist proud. She coded over 12,000 cases. She ran statistical analyses controlling for type of violation, defendant income level, legal representation, and time of day. The disparities persisted across every variable. They were systemic, predictable, measurable. She compiled her findings into a 47-page report with tables, graphs, and appendices. She titled it Disparate Justice: Racial Bias in Jefferson County Traffic Courts. She sent it to the Indianapolis Star, the Indiana ACLU, the Governor's Office, the State Attorney General, and the Chief Justice of the Indiana Supreme Court. Then she waited. The response came faster than she expected. 3 days after she sent the report, her office phone rang. The caller ID showed an unfamiliar number with a Washington, D.C. area code. Dr. Carter, this is Margaret Rivera from the Department of Justice, Civil Rights Division. We've received your report on Jefferson County traffic courts. I'd like to discuss it with you at your earliest convenience. Simone's pulse quickened, but her voice remained steady. I'm available now. Dr. Carter, your analysis is extraordinary. The methodology is sound. The data is compelling. We've been monitoring complaints about Jefferson County for several years, but we've never had documentation this comprehensive. Would you be willing to serve as a cooperating witness in a federal civil rights investigation? Yes. No hesitation. No qualification. Just yes. The Department of Justice investigation moved with the methodical precision of a legal machine built for exactly this purpose. Margaret Rivera assembled a team of 6 attorneys, 2 data analysts, and a forensic video expert. They descended on Indianapolis in late October, like archaeologists, excavating a site everyone knew was there, but no one had properly documented. They interviewed 43 witnesses, traffic defendants who'd been dismissed or ignored, court staff who'd seen patterns but felt powerless to speak, other judges who'd noticed irregularities but remained silent to preserve collegial relationships. The interviews were conducted in private office spaces, sometimes in people's homes, always with the explicit promise of protection against retaliation. Terrence, the law student who'd recorded Simone's assault, sat in a conference room at the federal courthouse and gave his formal statement. He'd documented not just that one incident, but had returned to Judge Whitmore's courtroom 6 more times. always recording, always observing. His videos showed a consistent pattern. Black defendants treated more harshly. White defendants given more time to speak. Black defendants interrupted more frequently. White defendants addressed with more courtesy. I started going back because I couldn't believe what I'd seen was normal, Terrence told the DOJ attorneys. I thought maybe it was a bad day, but it wasn't. It was every day. It was the system working exactly as designed. The DOJ team reviewed 5 years of video footage from courthouse security cameras. Thousands of hours. They used artificial intelligence to scan for specific behaviors. Physical contact between security personnel and defendants. The duration of time defendants were allowed to speak. The number of interruptions during testimony. The AI flagged 317 incidents of potential excessive force by courthouse security staff. Bailiff Eugene Watts appeared in 92 of those incidents. That was more than any other security officer in the courthouse. Not even close. They analyzed Judge Whitmore's case files with the same granular attention Simone had applied. But they went deeper. They cross-referenced her decisions with federal sentencing guidelines, with state judicial canons of conduct, with her own written opinions in similar cases involving white defendants. The contradictions were glaring. In one case, a white defendant named Jennifer Morrison contested a speeding ticket with dashcam footage. Judge Whitmore reviewed the footage in court, found discrepancies with the officer's testimony, and dismissed the citation with an apology for the inconvenience. 3 weeks later, a black defendant named Marcus Hamilton presented nearly identical evidence in nearly identical circumstances. Judge Whitmore refused to review it, found him guilty, and doubled his fine for wasting the court's time. The DOJ attorneys documented 38 parallel cases like this over 18 months. Same violations, same evidence, radically different outcomes. The statistical probability of this occurring by chance was less than 0.01%. This wasn't coincidence. This was conscious bias operating under the cover of judicial discretion. Meanwhile, Bailiff Eugene Watts remained on duty. Howard Chen, the deputy courthouse administrator, had placed him on administrative assignment pending investigation. That meant Watts no longer worked in courtrooms. Instead, he was assigned to monitor the parking garage security cameras in the basement. He sat in a small room with 4 screens and did nothing for 8 hours a day. He still received his full salary. He still had his badge and his access to the building. Simone learned this detail from a courthouse clerk who'd become a confidential source. The clerk, a woman named Patricia who'd worked in the building for 14 years, had been waiting for someone like Simone to emerge. They always protect their own, Patricia told her over coffee at a diner, 3 blocks from the courthouse. They shuffle them around, keep them out of sight until the heat dies down, then quietly reinstate them. I've seen it happen 6 times in my career here. Not this time, Simone said quietly. If you were in Simone's position right now, facing a system designed to outlast your outrage, what would you do? Share your thoughts in the comments. Officer Marcus Brennan also remained on active duty. He continued writing traffic citations, conducting stops, testifying in court. The Indianapolis Metropolitan Police Department's Internal Affairs Division opened an investigation into his testimony in Simone's case, but the investigation moved at glacial speed. 8 weeks in, they still hadn't interviewed him formally. They still hadn't reviewed his body cam footage from the traffic stop. They still hadn't compared his testimony to Simone's dashcam video. Simone attended every public meeting of the Jefferson County Court Oversight Committee. These meetings happened monthly in a conference room on the 6th floor of the courthouse. Attendance was usually sparse, maybe 5 or 6 people, mostly attorneys with specific grievances. But after Simone's case became public, after the Indianapolis Star ran a front-page story titled, "Doctor Alleges Assault and Bias in Traffic Court," attendance swelled. 40 people showed up to the November meeting. 63 came in December. By January, the conference room couldn't hold everyone. They moved the meeting to the main auditorium. People told stories that sounded like variations on the same theme. A black woman named Claudia described being yelled at by Bailiff Watts for asking where the restroom was located. A Latino man named Roberto described being told by Judge Whitmore that people like you should know better than to waste the court's time. A young white woman named Ashley described watching a black defendant get dragged out of the courtroom for the same behavior. Mild frustration at an unfair ruling that white defendants displayed regularly without consequence. Simone sat in the audience during these meetings and took notes. She didn't speak. She didn't need to. Her presence was enough. People saw her, recognized her from the news coverage, and felt emboldened to share their own experiences. The patterns became undeniable, not because of statistics or data analysis, but because of the accumulation of human testimony, story after story, voice after voice. The Indianapolis Star assigned an investigative reporter named Kevin Chen to cover the story full-time. Kevin was 32, Korean-American, with a background in data journalism. He'd won a regional Emmy for an investigation into nursing home abuse. He recognized that Simone's case wasn't just about one assault or one biased judge. It was about systems operating in plain sight, protected by the assumption that judges and law enforcement wouldn't lie under oath. Kevin obtained personnel files for all courthouse security staff through public records requests. The county fought the requests initially, claiming personnel files were exempt from disclosure. Kevin appealed to the state's public access counselor. The counselor ruled in his favor. The files revealed that complaints against courthouse security had been systematically underreported and underinvestigated for at least a decade. Bailiff Watts's 17 complaints were just the visible tip of a much larger problem. Other security officers had similar patterns. One bailiff, a man named Thomas Green, had 23 complaints over 9 years. Another, a woman named Sandra Phillips, had 14 complaints over 6 years. All were still employed. None had faced serious discipline. Kevin published his findings in a Sunday long-form feature titled, "The Courthouse No One Sees." The article went viral. It was shared 43,000 times on social media within 48 hours. National outlets picked it up. CNN ran a segment. NPR did a 12-minute piece on Morning Edition. Suddenly, what happened to Simone in Courtroom 7A wasn't just a local story. It became a national conversation about judicial accountability and institutional bias. The pressure mounted. Protesters gathered outside the Jefferson County Courthouse every Friday afternoon for 6 consecutive weeks. They weren't angry mobs. They were organized, disciplined, carrying signs with specific demands. Remove Judge Whitmore. Fire Bailiff Watts. Reform courthouse security training. Implement body cameras for all courtroom personnel. Create an independent oversight board with real enforcement power. Simone attended the protests, but didn't lead them. She stood in the crowd, watched, listened, and occasionally spoke with reporters when asked. "This isn't about me," she told a CNN correspondent. "This is about every person who walked into that courthouse, believing they'd receive fair treatment, and walked out knowing the system wasn't designed for them. I had resources and credentials and connections. Most people don't. They just absorb the injustice and move on, because fighting it seems impossible." The reporter asked, "Do you think change is possible?" Simone looked directly into the camera. "I think change is inevitable when enough people refuse to accept the status quo. The question isn't whether change is possible. The question is whether we have the courage to demand it and the patience to see it through." In February, 5 months after Simone was slammed against that courtroom wall, the Department of Justice released its findings. The report was 173 pages long. It was methodical, devastating, irrefutable. The DOJ found that Jefferson County traffic courts engaged in a pattern and practice of racial discrimination that violated the 14th Amendment's Equal Protection Clause. The evidence was overwhelming. Statistical analysis showed systematic disparities in how cases were adjudicated based on defendant race. Video analysis showed differential treatment in courtroom interactions. Witness testimony corroborated both. Judge Eleanor Whitmore was named specifically in the report. The DOJ found that she had demonstrated conscious and unconscious bias in her judicial decision-making that resulted in measurably harsher outcomes for Black and Latino defendants compared to similarly situated white defendants. The report recommended she be removed from the bench and referred to the State Judicial Discipline Commission for potential sanctions. Bailiff Eugene Watts was also named. The DOJ found that he had engaged in a pattern of excessive force disproportionately directed at Black defendants and visitors to the courthouse, creating an atmosphere of intimidation that chilled access to justice. The report recommended his immediate termination and referral to the county prosecutor for potential criminal charges related to assault under color of law. Officer Marcus Brennan faced similar findings. The DOJ determined he had provided materially false testimony under oath in multiple proceedings and recommended referral to the State Attorney General for prosecution. The report included 43 specific recommendations for systemic reform: mandatory body cameras for all courthouse security personnel, creation of an independent civilian oversight board with subpoena power, quarterly publication of disaggregated case outcome data by race, violation type, and judge, mandatory implicit bias training for all judges and court staff, revision of courthouse security protocols to prohibit physical contact except in cases of imminent threat to safety. Jefferson County had 90 days to respond with a compliance plan. If they failed to comply, the DOJ would file a federal civil rights lawsuit seeking a consent decree with court-enforced oversight. The local response was immediate and fractured. The county commissioners, elected officials responsible for courthouse funding and administration, split along predictable lines. The 3 Democratic commissioners supported full compliance with DOJ recommendations. The 2 Republican commissioners called the report federal overreach and vowed to fight it in court. Judge Whitmore issued a statement through her attorney. She denied all allegations of bias. She claimed she had treated every defendant fairly and impartially throughout her career. She said the statistical analysis was flawed because it didn't account for behavioral differences between defendants. That phrase, behavioral differences, became a flashpoint. Critics pointed out it was coded language, a way of suggesting Black defendants deserved harsher treatment because of how they allegedly acted, not because of bias in how they were perceived. Bailiff Watts remained silent. His union, the Jefferson County Courthouse Employees Association, issued a statement defending him as a dedicated public servant who had served with honor for 26 years. They claimed the allegations against him were exaggerated and politically motivated. They didn't address the video evidence. Officer Brennan hired a lawyer. The lawyer gave a press conference outside police headquarters. Officer Brennan stands by his testimony, the lawyer said. He reported what he observed truthfully and accurately. The suggestion that he committed perjury is baseless and defamatory. We will defend him vigorously against any charges. Simone watched all of this unfold from her office at the Bureau of Correctional Health Services. She had continued her work throughout the investigation, managing health care for 37,000 incarcerated individuals across the state. She'd traveled to prisons, reviewed medical records, testified before legislative committees about health care funding. She had not become a full-time activist. She had simply refused to let the assault define her or derail her. But she also refused to let it be forgotten. When the DOJ report was released, she gave one interview. Just one. She chose Terrence, the law student who'd recorded her assault, who'd become a stringer for the Indianapolis Star while finishing his degree. They met at a coffee shop near the Indiana University campus. Terrence set up his recorder carefully. He'd done maybe 20 interviews at this point, but this one felt different. This was the source, the beginning of the story that had consumed his life for 5 months. Dr. Carter, how do you feel about the DOJ findings? Simone took a moment before answering. She sipped her coffee. She looked out the window at students walking past, bundled against February. cold, earbuds in, oblivious to history happening around them. "I feel validated," she said finally, "but I don't feel satisfied. Validation doesn't create change. Reports don't create accountability. What matters now is implementation. What matters is whether Jefferson County actually reforms, or whether this report becomes another document gathering dust, while the same patterns continue under slightly modified procedures." Do you think Judge Whitmore should be removed? I think Judge Whitmore forfeited her right to serve when she watched a bailiff assault a defendant and chose to threaten the victim with contempt rather than address the assault. That's not a lapse in judgment. That's a fundamental betrayal of the judicial oath. Yes, she should be removed. What about Bailiff Watts? Bailiff Watts should be prosecuted. He committed assault in front of witnesses and cameras. The fact that he's still employed, still receiving a paycheck, still walking around with a badge, tells you everything about how this system values accountability. If I had grabbed him and thrown him against a wall, I'd be in jail. The standard should be the same. And Officer Brennan? Officer Brennan lied under oath. That's perjury. That's a crime. If the system treats his false testimony as anything less than criminal conduct, it sends a message that truth doesn't matter, that the oath means nothing, that you can lie in court as long as you're wearing a badge. Terrence paused. He looked at his notes. Dr. Carter, you could have just paid the fine and moved on. You had the resources to absorb it. Why didn't you? Simone met his eyes. Because absorbing injustice isn't the same as accepting it. Because every person who's been dismissed and disrespected in that courthouse deserves to know they weren't wrong. The system was. Because my children are watching. Because your generation is watching. Because change doesn't happen when we decide justice isn't worth the inconvenience. The interview ran in full, nearly 3,000 words, on the front page of the Sunday edition. It was the most read story in the Indianapolis Star's digital history. It was shared 76,000 times. The pressure became unbearable for the institutions involved. The State Judicial Discipline Commission, which had been quietly reviewing Judge Whitmore's conduct, accelerated its proceedings. In March, they held a public hearing. Simone testified. Terrence testified. 37 other witnesses testified about their experiences in Judge Whitmore's courtroom. The commission's decision came in April. Judge Eleanor Whitmore was removed from the bench, effective immediately. She was barred from seeking judicial office in the future. She was fined $25,000 for judicial misconduct. In their written decision, the commission stated, Judge Whitmore's conduct demonstrated a pattern of bias so egregious and sustained that it undermined public confidence in the entire judicial system. Her failure to address Bailiff Watts' assault on Dr. Carter, combined with her threat to hold the victim in contempt, represents an inexcusable abuse of judicial authority. Bailiff Eugene Watts was fired in May. The county prosecutor, facing intense public pressure and overwhelming evidence, filed criminal charges: assault under color of authority, a felony carrying up to 5 years in prison. Watts pleaded not guilty. His trial was scheduled for September. Officer Marcus Brennan resigned from the Indianapolis Metropolitan Police Department before the department could complete its investigation. The state attorney general declined to file perjury charges, citing difficulties in proving criminal intent beyond a reasonable doubt. This decision sparked outrage. Protesters gathered outside the attorney general's office demanding accountability. The attorney general, facing re-election that November, eventually agreed to appoint a special prosecutor to review the case. The review was ongoing. Before we go deeper, I would love to hear your point of view. Tell me what part hit you the hardest in the story, and share your thoughts in the comments. But the real transformation wasn't in these individual accountability measures. As significant as they were, the real transformation was in the systematic changes that followed. Jefferson County implemented every single recommendation in the DOJ report. Not because they wanted to, because they had to. The federal government made compliance a condition of continued funding for courthouse operations. The county commissioners, facing a budget crisis if they refused, voted 4-1 to accept the consent decree. Body cameras were installed for all courthouse security personnel by June. The cameras were required to be activated whenever security staff interacted with defendants or visitors. Footage was retained for 5 years and could be requested by the public through standard records processes. Disabling a camera or failing to activate it during an interaction resulted in automatic suspension pending investigation. The cameras changed everything. Within the first month, complaints against security staff dropped by 62%, not because behavior improved overnight, but because security personnel knew they were being watched. The second-order effect was even more significant. When complaints were filed, they were resolved quickly because the video evidence eliminated he said, she said disputes. Of the complaints filed in the first 6 months, 73% were sustained. Before cameras, that number had been below 5%. An independent civilian oversight board was created in July. The board had 7 members appointed by different stakeholders: 2 by the county commissioners, 2 by the city council, 1 by the local NAACP chapter, 1 by the County Bar Association, and 1 by a coalition of community organizations. The board had subpoena power. It could compel testimony. It could review personnel files. It could recommend disciplinary action to the courthouse administrator, and those recommendations carried real weight because the board's decisions were subject to public disclosure and press coverage. The board met monthly. Its meetings were live-streamed. Minutes were published online within 48 hours. People could submit complaints directly to the board, bypassing the courthouse administration entirely. In its first year, the board received 347 complaints. It investigated every single one. It sustained 91, resulting in consequences ranging from mandatory retraining to termination. Quarterly publication of case outcome data became standard practice. The county clerk's office created an online dashboard where anyone could see how different judges handled different cases. The data was disaggregated by race, violation type, fine amount, and whether the defendant had legal representation. Patterns that had been invisible or deniable became glaringly obvious. When the first quarter of data was published in August, it showed that the racial disparities that had defined Judge Whitmore's courtroom were not unique to her. 3 other traffic judges showed similar, though less extreme, patterns. The data sparked immediate action. The chief judge of Jefferson County Courts called a mandatory training session for all judicial officers. Implicit bias experts were brought in. The training wasn't perfunctory. It lasted 3 full days and included exercises where judges reviewed their own past decisions while blind to defendant race, then compared those hypothetical decisions to their actual decisions. The discrepancies were illuminating and uncomfortable. By the fourth quarter, the data showed measurable improvement. The conviction rate gap between black and white defendants for identical violations had narrowed from 28 percentage points to 11. The average fine gap had narrowed from $47 to $18. This wasn't equality yet, but it was movement in the right direction, and the public transparency meant continued progress was expected, demanded, monitored. Courthouse security protocols were completely rewritten. Physical contact with defendants or visitors was prohibited except in cases of imminent threat to safety, defined specifically as when a person was actively assaulting someone else or had displayed a weapon. Verbal de-escalation became the first and primary response to any perceived disruption. Security officers received 80 hours of training in conflict resolution, mental health crisis intervention, and cultural competency. The training was developed in partnership with the Indiana Crisis Intervention Team, the same organization that trained police officers in handling mental health emergencies. The new protocols were tested almost immediately. In September, a man experiencing what appeared to be a mental health crisis began shouting in the hallway outside a family court hearing. Under the old protocols, security would have grabbed him, possibly restrained him, possibly thrown him to the ground. Under the new protocols, 2 security officers approached calmly, spoke to him in quiet voices, asked what he needed, listened to his concerns, and ultimately connected him with a courthouse social worker who helped him navigate the system. No force, no trauma, no lawsuit. Just human beings, treating another human being with dignity during a moment of vulnerability. The transformation wasn't limited to Jefferson County. The DOJ report and Simone's case inspired similar reviews in other jurisdictions across Indiana and beyond. Marion County, the state's largest county, commissioned an independent audit of its traffic courts. The audit found patterns similar to those in Jefferson County, though less severe. Marion County implemented body cameras and an oversight board before the federal government got involved. Lake County followed. St. Joseph County followed. By the end of the year, 14 of Indiana's 92 counties had implemented some version of the reforms pioneered in Jefferson County. The state legislature, responding to overwhelming public pressure, passed the Indiana Courthouse Accountability Act in November. The legislation, which had bipartisan support, mandated body cameras for courthouse security statewide, created minimum standards for judicial training in implicit bias, and required all courts to publish quarterly data on case outcomes, disaggregated by race and ethnicity. Governor Michael Torres, who had received Simone's initial text message from the courtroom that day in September, signed the bill into law in a public ceremony. He invited Simone to stand beside him as he signed. She wore the same blouse she'd worn to court that day, now carefully mended at the shoulder seam. The brass nameplate on her briefcase, still dented, sat on the signing table. Dr. Carter didn't set out to change state policy, Governor Torres said to the assembled crowd of reporters and advocates. She set out to pay a traffic ticket. But when she was assaulted for the crime of being black and professional in a space that didn't expect her to be either, she made a choice. She chose documentation over silence. She chose systematic analysis over individual grievance. She chose to show us what we already knew, but refused to see. This law exists because she refused to let injustice be routine. Simone spoke briefly. This law is named after a place, but it's really about people. It's about every person who's been dismissed, disrespected, or harmed by systems that were supposed to serve them. It's about creating accountability not through individual lawsuits that take years and drain resources, but through transparent data and independent oversight that make bias visible and costly. I hope other states follow Indiana's example. I hope this becomes normal, expected, required everywhere. The Courthouse Accountability Act was signed on November 12th, 1 year and 2 months after Simone was thrown against that marble wall. Meanwhile, Bailiff Eugene Watts's criminal trial proceeded. His attorney argued that Watts had acted reasonably based on his perception of threat, that his 26 years of service demonstrated his commitment to safety, that one incident shouldn't define his entire career. The prosecution presented the video evidence, Simone's testimony, Terrence's testimony, and expert analysis showing that Watts had used force far beyond what any reasonable officer would consider necessary. The jury deliberated for 7 hours. They found him guilty of assault under color of authority. The judge sentenced him to 18 months in prison, suspended after serving 6 months, followed by 2 years of probation. It wasn't a harsh sentence by any standard, but it was significant because it was a sentence at all. Bailiffs and courthouse security officers were almost never criminally prosecuted for excessive force. The conviction sent a message. Accountability was possible, even for people who'd operated with impunity for decades. Watts served his 6 months at a minimum security facility in southern Indiana. He was released in August. He now works private security at a shopping mall, checking receipts and monitoring parking lots. He gives no interviews. He makes no public statements. People who knew him say he's different now, quieter, more cautious, carrying weight that wasn't visible before. Officer Marcus Brennan's case took a different trajectory. The special prosecutor appointed to review potential perjury charges ultimately declined to file them, citing the same concerns about proving criminal intent. But Brennan's resignation from the police department was permanent. He couldn't be rehired. Other departments wouldn't touch him because of the cloud of controversy. He enrolled in community college to study social work, According to people who've encountered him, he talks about wanting to help people instead of arresting them, about understanding the harm caused by systems he once served without question. In October, Brennan sent Simone a handwritten letter. 7 pages, single-spaced, written in careful script. He apologized. He explained how his training had taught him to see certain people as threats, how the culture of policing had reinforced those biases, how testifying in court had become routine and performative rather than truthful. He said he watched the video of himself smirking in that witness box and felt ashamed. He said he understood if she never forgave him, but he needed her to know he was trying to become someone different. Simone read the letter twice. She didn't respond. She placed it in a folder in her desk drawer, alongside the dented brass nameplate she'd never replaced. Forgiveness, she believed, wasn't something you gave on demand. It was something that emerged slowly, through demonstrated change over time. Maybe someday she'd respond, maybe not. The letter's existence was enough for now. Judge Eleanor Whitmore's trajectory was perhaps the most unexpected. After her removal from the bench, she spent several months in what she later described as a period of deep reflection. She read books on racial justice. She attended workshops on implicit bias. She volunteered with a reentry program that helped formerly incarcerated people navigate the legal system. Judge Eleanor Whitmore began teaching a seminar at the Indiana University McKinney School of Law in January. The course was called Judicial Accountability and Implicit Bias. She team-taught it with Professor Diana Mitchell, an expert in constitutional law and criminal justice reform. The syllabus included the DOJ report on Jefferson County as required reading. Week 4 was devoted entirely to analyzing Whitmore's own decisions, including her handling of Simone's case. Students were uncomfortable at first. How do you critique a professor's documented misconduct to her face? But Whitmore insisted on it. She made them dissect her decisions line by line. She made them identify the moments where bias influenced her judgment. She made them compare her treatment of defendants across racial lines. She didn't defend herself. She didn't make excuses. She used her failure as a teaching tool. I thought I was being fair, she told the class during one particularly difficult session. I genuinely believed I treated everyone the same. But belief doesn't equal reality. Intent doesn't erase impact. I was looking at the same facts differently depending on who stood in front of me. And I convinced myself those differences were based on behavior rather than bias. That's how these systems perpetuate themselves, through good people telling themselves they're being fair, while the data shows otherwise. The seminar became one of the most requested courses at the law school. Students who took it reported that it changed how they thought about justice, about their future roles as attorneys and judges, about the responsibility that comes with institutional power. Several students went on to clerk for judges who were implementing reforms based on the Jefferson County model. The ripple effect was real and measurable. Terrence graduated from law school in May with honors. His senior thesis analyzed the Jefferson County case as a model for using data-driven advocacy to challenge systemic bias. The thesis was published in the Indiana Law Review and cited by advocates in 3 other states pursuing similar reforms. He accepted a position with the Indiana ACLU's Criminal Justice Reform Project. His first assignment was helping counties implement the Courthouse Accountability Act. He was 26 years old and already shaping policy. The video he'd recorded that September afternoon, Simone being slammed against the wall, Judge Whitmore's dismissive response. The entire 7-minute sequence was included in a training module used by courthouse security personnel across Indiana. It was difficult to watch. That was the point. The training facilitators would play the video, pause at key moments, and ask, "What do you see happening here? What could have been done differently? What does accountability look like in this moment?" Security officers who'd been skeptical of the reforms, who'd complained about body cameras and new protocols, often changed their perspective after seeing the video. It wasn't abstract anymore. It wasn't about statistics or policy papers. It was about a professional woman being violently grabbed for the crime of standing in a courtroom where she had every legal right to be. The visual evidence made denial impossible. Simone continued her work at the Bureau of Correctional Health Services. She was promoted to deputy commissioner in March, overseeing not just health care, but also mental health services and addiction treatment programs across the state's prison system. She used the same methodical approach she'd applied to courthouse reform: data collection, pattern analysis, systematic documentation of disparities and gaps in care. She discovered that Black and Latino prisoners were significantly less likely to receive mental health treatment compared to white prisoners with identical diagnostic criteria. She documented this in a 90-page report that she submitted to the state legislature's Corrections Oversight Committee. The committee held hearings. Reforms were implemented. Funding was allocated. Mental health screening became mandatory within 72 hours of incarceration. Treatment plans were required to be reviewed monthly by licensed clinicians. Racial disparities in treatment access narrowed measurably within 18 months. Simone's methodology became a template used by advocates across the criminal justice system: collect data, identify patterns, document disparities, present evidence, demand accountability. It wasn't flashy. It wasn't dramatic. It was systematic, rigorous, and extraordinarily effective. In September, exactly 2 years after the assault, the Indianapolis Star published a comprehensive retrospective examining the impact of Simone's case. Kevin Chen, the investigative reporter who'd covered the story from the beginning, spent 3 months interviewing everyone involved and analyzing outcome data. The numbers told a powerful story. Complaints filed with Jefferson County's Civilian Oversight Board had increased by 347% compared to the 2 years before its creation. This wasn't because courthouse conditions had deteriorated. It was because people finally believed someone in authority would actually listen and take action. The board investigated every complaint thoroughly. Sustained complaints resulted in real consequences. The racial disparity in guilty findings for traffic violations in Jefferson County had narrowed from 28 percentage points to 6. The average fine disparity had narrowed from $47 to $9. Use of force incidents by courthouse security had dropped by 81%. Not a single excessive force complaint had been filed against security personnel in 14 months. The body cameras, the training, the oversight, all of it was working. Other counties that had implemented similar reforms showed comparable results. Marion County saw a 63% reduction in courthouse security complaints in the first year after implementing body cameras. Lake County's traffic court data showed narrowing racial disparities in conviction rates and fine amounts. The reforms were replicable, scalable, and demonstrably effective. But the story wasn't just about statistics. Kevin Chen interviewed people who'd been affected directly by the changes. A Black woman named Tasha described going to traffic court in Jefferson County in August, 2 years after Simone's case. She'd been nervous, expecting to be treated with suspicion or hostility. Instead, she was greeted politely by security staff wearing visible body cameras. The judge listened to her explanation, reviewed her evidence, and reduced her fine. "I couldn't believe it," Tasha told Kevin. "I kept waiting for the other shoe to drop, but it was just fair, normal, the way it should have been all along." A white attorney named Michael, who'd practiced in Jefferson County traffic courts for 15 years, noticed the difference immediately. "The culture changed," he said. "Judges are more careful. Security is more professional. There's accountability in the air. People know they're being watched, and it matters. It shouldn't take cameras and oversight boards to make people act right. But if that's what it takes, then that's what it takes." The retrospective article ran on the front page under the headline, "2 Years Later, How One Woman's Fight Changed Indiana Justice." It included photos of Simone at her office, the dented brass nameplate on her desk, the mended blouse hanging in her closet. The article was shared 132,000 times across social media platforms. National attention followed. Simone was invited to speak at the National Conference of State Court Administrators in Denver. 400 judicial officials from 46 states attended. She stood at the podium without notes or teleprompter and delivered a 20-minute speech that became a defining moment in the conversation about judicial reform. "I didn't set out to become a spokesperson," she began. "I went to Jefferson County Courthouse to pay a traffic ticket for driving 4 miles over the speed limit. But when power is abused casually, routinely, without thought or consequence, when a hand grabs a wrist and a gavel dismisses evidence without genuine consideration, it reveals something much deeper than individual misconduct. It reveals infrastructure, system design." She paused. The room was completely silent. 400 people, many of them judges and court administrators who'd operated under the old assumptions for decades, listened. "We changed Jefferson County not because I'm a doctor with an impressive title. We changed it because I had access to data and the patience to compile it systematically over 18 months. Most victims of courthouse bias don't have that access. They don't have those resources. They don't have 18 months to build a case. That's exactly what we must fix. Not just punishing individual bad actors after the damage is done. Changing the systems that make abuse routine and predictable." The audience gave her a standing ovation that lasted 4 full minutes. People weren't just clapping politely. They were on their feet, moved by what she'd said and how she'd said it. Several judges approached her afterward, asking for specific guidance on implementing reforms in their own jurisdictions. She spent 3 hours in the hotel conference room after the speech, sharing her data methodology, her analytical framework, her strategic approach to advocacy. Simone's case inspired legislation beyond Indiana. The National Association of State Court Administrators formally endorsed the Jefferson County reforms as a model in November. 5 states introduced courthouse accountability bills in the following legislative session. Colorado passed its version in April. Oregon passed its version in June. Minnesota passed its version in August. Each law had variations tailored to local contexts, but all included the core elements: body cameras, civilian oversight, transparent data publication, mandatory implicit bias training. The movement was growing, spreading, becoming institutionalized. What started with one woman being thrown against a wall in Indianapolis was becoming a national conversation about how courthouses operate and who they serve. 3 years after the assault, Simone sat in her office on a quiet Friday afternoon and reviewed incident reports from across Indiana's courthouse system. The data showed continued progress. Use of force incidents were down statewide by 73% compared to pre-reform baselines. Racial disparities in traffic court outcomes had narrowed in 47 of Indiana's 92 counties. The remaining counties were under review by the civilian oversight boards, facing public pressure to explain why their numbers lagged behind the state average. Her assistant, a young woman named Keisha, who'd been hired specifically to manage the growing volume of requests for Simone's expertise and time, knocked on the doorframe. "Dr. Carter, there's someone here to see you. She doesn't have an appointment, but she says it's important." Simone looked up from her computer. "Who is it?" "Her name is Maria Gonzalez. She says you changed her life, and she wanted to thank you in person." Simone had received dozens of these visits over the past 3 years. People who'd been affected by the courthouse reforms, who'd experienced fair treatment where they'd expected bias, who wanted to express gratitude. She always made time for them. "Send her in." Maria was 32, Latina, wearing business casual clothes and carrying a leather portfolio. She introduced herself as an attorney with the Colorado ACLU's Criminal Justice Project. She'd been working on courthouse reform in Denver using the Jefferson County model. "Dr. Carter, I was in Judge Whitmore's courtroom 4 years ago. I was there for a speeding ticket. I watched her dismiss a white woman's case after reviewing dashcam evidence, and then 30 minutes later, I watched her refuse to review my dashcam evidence for the exact same violation. I paid a $350 fine that day. But worse than the money was the feeling that the system wasn't designed for people who looked like me." Simone listened without interrupting. "When I read about your case in the news, I felt something shift. I felt like someone had finally said out loud what I'd known, but couldn't prove. I started documenting cases in Denver. I built a database just like you did. Last year, Denver implemented body cameras for courthouse security and created a civilian oversight board. We used your reports, your methodology, your framework, and it's working. Complaints are being investigated. Disparities are narrowing. People are being held accountable. Maria's voice caught slightly. I wanted you to know that what you didn't just change Indiana. It changed how advocates across the country think about this work. You showed us that data can defeat denial. You showed us that one person, with patience and precision, can shift an entire system. Thank you. Simone stood and walked around her desk. She shook Maria's hand, then pulled her into a brief hug. Thank you for continuing the work. That's what makes change sustainable. Not one case, not one report, but a movement of people documenting, analyzing, demanding accountability in every jurisdiction where bias operates. After Maria left, Simone returned to her desk. She opened a drawer and pulled out the dented brass nameplate from her briefcase. She'd kept it as a reminder, a physical artifact of the moment everything changed. The dent was still visible, a groove running through the engraved letters of her title. She'd been offered replacements multiple times. She'd declined every time. When you look at the systems in your own community, the courts, the police, the institutions that hold power, do you see accountability or just the appearance of it? What would you document if you had the courage and the tools? Scars are data too, she thought. They tell you what happened and why it mattered. In November of that year, the Jefferson County Civilian Oversight Board published its 3-year impact report. The document was 64 pages long, dense with statistics and case studies. The findings were remarkable. The board had reviewed 1,047 complaints against courthouse personnel in 3 years. It had sustained 293 of them, a sustained rate of 28%, dramatically higher than the sub-5% rate from before the board existed. Consequences for sustained complaints ranged from mandatory retraining to termination. 12 courthouse employees had been fired for violations documented by body camera footage. 47 had received formal reprimands. 162 had completed additional training in de-escalation and implicit bias. The accountability was real, consistent, and transparent. The report also analyzed courthouse climate through annual surveys of people who'd interacted with the court system. In the year before the reforms, 31% of respondents reported feeling treated fairly and respectfully by courthouse security. 3 years later, that number had risen to 79%. Among Black and Latino respondents specifically, the increase was even more dramatic, from 18% to 71%. People's lived experiences were changing. That was the ultimate measure of success. Simone was invited to present the Jefferson County model at Harvard Law School's Criminal Justice Policy program in December. She flew to Boston on a cold Tuesday morning and delivered a lecture to a packed auditorium of law students, professors, and practitioners. The lecture was titled Documentation as Disruption: Using Data to Challenge Systemic Bias. She walked through the entire case chronologically: the assault, the dismissal, the decision to fight rather than absorb, the systematic data collection, the DOJ investigation, the reforms, the measurable outcomes. She showed videos, including the footage Terrence had recorded. She displayed graphs showing the narrowing of racial disparities. She shared testimonies from people whose lives had been affected by the changes. At the end, during the question and answer session, a student asked, "Dr. Carter, what advice would you give to someone who experiences injustice, but doesn't have your resources or credentials or connections?" Simone thought about this carefully before answering. I had advantages. Yes. But those advantages only mattered because I used them. The video evidence only mattered because I documented it and shared it publicly. The data only mattered because I spent 18 months compiling it systematically. The resources that made the difference weren't money or status. They were patience, precision, and refusal to let the system outlast my outrage. She paused. If you experience injustice, document it. Date, time, location, names, badge numbers. Take photos. Take video, if it's safe. File formal complaints, even if you don't think anyone will read them. Because those complaints create records that can be analyzed later for patterns. Connect with others who've had similar experiences. Share information. Build coalitions. And remember that institutions change, not because they want to, but because staying the same becomes more costly than reform. The student nodded, taking notes. Another student raised her hand. Do you think change is permanent? Or could these systems revert once public attention fades? Change is permanent only if it's institutionalized, Simone replied. Body cameras can be turned off. Oversight boards can be defunded. Data publication can be suspended. That's why accountability can't depend on individual good actors or temporary political will. It needs to be embedded in law, policy, budget, and culture. That's what we did in Indiana. We didn't just shame people into better behavior. We changed the rules so better behavior became required, monitored, and enforced. The lecture was recorded and posted online. It was viewed 47,000 times in the first month. Law schools across the country began using it as a teaching tool in courses on civil rights litigation, criminal justice reform, and advocacy strategy. Back in Indianapolis, life continued in its transformed state. Jefferson County courthouses operated with body cameras and civilian oversight as the new normal. Judges made decisions knowing their data would be scrutinized publicly. Security personnel interacted with defendants, knowing their conduct was being recorded and reviewed. The culture had fundamentally shifted, but Simone knew the work wasn't finished. In October, she read news coverage of a courthouse incident in Phoenix, Arizona. A young Latino man had been shoved by security for asking a question about his hearing location. Video was going viral. Thousands of comments demanded accountability. She recognized the pattern immediately. She sent a message to the ACLU of Arizona, offering to share the Jefferson County data methodology and reform framework. They accepted within hours. 2 weeks later, she was on a plane to Phoenix, meeting with advocates who were building the same kind of systematic case she'd built 3 years earlier. The work was spreading. The model was replicating. The movement was growing beyond any one person or case. That's how real change happens, not through individual heroism, but through shared strategy, collective action, and persistent refusal to accept injustice as inevitable. On a quiet evening in March, 4 years after the assault that changed everything, Simone sat in her home office with the lights dimmed. She was reviewing applications for a new fellowship program she'd created, the Courthouse Accountability Fellowship, which would fund law students and community advocates to conduct courthouse audits in jurisdictions across the country. 57 applications had come in for 5 spots. Every applicant referenced her case as inspiration. She read through them carefully. A law student in Atlanta wanted to analyze racial disparities in municipal court fine collections. A community organizer in Milwaukee wanted to document use of force by courthouse security. A public defender in New Orleans wanted to create a database tracking judicial decisions by race and case type. Each application reflected the same core insight. Systems don't change through individual lawsuits that take years and drain resources. They change through systematic documentation that makes bias visible, measurable, and undeniable. Keisha knocked on the doorframe. "Dr. Carter, there's a call for you. It's Judge Eleanor Whitmore." Simone hadn't spoken to Whitmore since the judicial discipline hearing 4 years ago. She hesitated for a moment, then picked up the phone. "This is Dr. Carter." "Dr. Carter, this is Eleanor Whitmore. I know I have no right to call you, and I'll understand if you hang up, but I wanted to tell you something I should have said 4 years ago. I'm sorry. I'm sorry for dismissing you. I'm sorry for threatening you with contempt when you were the victim. I'm sorry for every decision I made that prioritized protecting the system over serving justice. I was wrong. Completely, inexcusably wrong." Simone listened. Whitmore's voice was different, quieter, stripped of the judicial authority that had once made it commanding. I've spent the past 4 years trying to understand how I became someone who could watch a woman be assaulted and do nothing. The honest answer is that I stopped seeing people as individuals and started seeing them as categories. I saw you as a disruption rather than a person. I saw Bailiff Watts's word as automatically more credible than yours because he wore a badge and you didn't. I saw your calm professionalism as arrogance because it didn't match what I expected from someone who looked like you. I failed you. I failed every person who came before my bench trusting the system would treat them fairly. Whitmore paused. Simone could hear her breathing. I'm calling because I'm teaching a seminar next semester on judicial accountability, and I wanted to ask your permission to use your case as the central example. I want students to see exactly what I did wrong and why it mattered. I want them to learn from my failure, but I won't do it without your consent. Simone took a moment before responding. You can use the case. It's public record, but I appreciate you asking, and I appreciate the apology. Accountability isn't just about losing your job or paying fines. It's about genuine understanding of harm caused and commitment to preventing it from happening again. It sounds like you're doing that work. I'm trying, Whitmore said quietly. It doesn't erase what I did, but maybe it prevents the next judge from making the same mistakes. They talked for another 15 minutes. Whitmore described the seminar curriculum, the student responses, the difficult conversations about implicit bias and judicial power. Simone shared updates on the statewide reforms, the narrowing disparities, the cultural shift in courthouse operations. When they ended the call, something had shifted. Not forgiveness exactly, but recognition that change was possible, even for people who'd caused harm. Simone stood and walked to the window. Her neighborhood was quiet. Streetlights casting pools of yellow light on empty sidewalks. She thought about the journey that had brought her here. 4 years ago, she'd walked into a courthouse to pay a speeding ticket and walked out with bruises, a torn blouse, and a choice to make. She could have absorbed the injustice, paid the fine, moved on. No one would have blamed her. But absorption isn't the same as acceptance, and silence isn't the same as peace. She'd chosen documentation over silence, data over denial, systematic analysis over individual grievance. She'd spent 18 months compiling evidence that transformed personal injury into proof of systemic failure. She'd endured skepticism, criticism, and attempts to discredit her. She'd persisted because the alternative, letting the system continue harming people with impunity, was intolerable. The results spoke for themselves. Body cameras recording every interaction, civilian oversight boards with real enforcement power, transparent data showing who gets treated fairly and who doesn't, narrowing racial disparities in courthouse outcomes. A cultural shift from assuming law enforcement credibility to demanding evidence and accountability. One woman, one assault, one refusal to let injustice be routine. The ripple effects had reached across state lines, inspired legislative changes, transformed how courthouses operate in dozens of jurisdictions. Not because Simone was a hero or a symbol, but because she was meticulous, patient, and unwilling to let the system outlast her outrage. The brass nameplate on her desk caught the lamplight. The dent was still there, a permanent mark from the moment it hit the courthouse floor. She'd been offered replacements countless times. She'd kept the original because scars are data too. They tell you what happened. They remind you why the work matters. Her phone buzzed. A text message from Terrence, now a senior attorney with the Indiana ACLU. Phoenix just announced body cameras for courthouse security. They're using the Jefferson County model. Your model. This movement is unstoppable. Simone smiled. Unstoppable wasn't quite right. The movement could be stopped if people stopped documenting, stopped analyzing, stopped demanding accountability. But as long as there were people willing to do that work, people who refused to accept bias as inevitable and injustice as routine, the systems would keep changing. Slowly, imperfectly, but measurably. She opened her briefcase. The same briefcase from that September afternoon 4 years ago. Inside were folders for her current projects: healthcare disparities in state prisons, mental health treatment gaps for incarcerated youth, addiction services in county jails. Each folder contained the same approach: collect data, identify patterns, document disparities, present evidence, demand accountability. The methodology was transferable. The lessons were scalable. The work was endless but essential. These stories of resilience and quiet power matter more than ever. These stories of intelligence, defeating injustice, need to be amplified. These real-life stories of systemic change prove that injustice doesn't have to end with defeat and resignation. Simone Carter walked into a courtroom, invisible and dismissed. She walked out a catalyst for change across an entire state and beyond. This kind of transformation is possible everywhere. In your courthouse, in your community, in the systems you interact with every day that operate on assumptions of who deserves respect and who doesn't. Here's what I want you to take from Simone's story. Power unchecked is power that will be abused, but power documented is power that can be dismantled. Systems don't fix themselves. They need proof. They need pressure. They need people willing to endure discomfort and criticism for necessary change. If you've made it this far, I want to hear from you. What part of this story resonated most deeply? Have you or someone you know experienced dismissal or bias in a courthouse or government office? What would you document if you had the tools and the courage? Share your thoughts in the comments below. I read every single one, and your stories matter. If this story moved you, if it made you think differently about accountability and change, hit that like button and subscribe to Justice Stories. We're building a community of people who believe documentation defeats denial, who understand that change happens through systematic effort rather than individual heroism, who refuse to let injustice be routine. Share this video with someone who needs to hear it. Tag someone who's fighting their own battle against systems that weren't designed for them. Let them know they're not alone. Let them know change is possible. Be the person with the briefcase and the camera. Be the person who compiles the data. Be the person who refuses to let the system outlast your outrage. Be Simone Carter, not because you have her credentials or her resources, but because you have her patience, her precision, and her absolute refusal to accept that things can't change. The dent in that brass nameplate is still there. The blouse is still mended at the shoulder. The scars are still visible, but so is the transformation. 47 counties with narrowing racial disparities. 12 states considering courthouse accountability legislation. Hundreds of thousands of people treated more fairly because one woman refused to stay silent. Your documentation matters. Your voice matters. Your refusal to accept injustice as inevitable matters. Thank you for watching Justice Stories. Subscribe, share your thoughts, and let's keep building a movement where accountability isn't the exception, it's the rule.